A 72-year-old retired teacher from Manila keeps $8,000 in her hometown bank to pay her mother's medical bills. She files taxes honestly every year. And starting in 2027, the United States government could freeze her accounts, impose $30,000 in penalties, and block her citizenship application. Her violation? Failing to report a foreign bank account she never knew required disclosure. This is not a hypothetical scare tactic. This is the documented reality of what the Financial Crimes Enforcement Network calls the Enhanced Foreign Account Mandatory Reporting System, a 2026 rule change that fundamentally restructures how America monitors the financial lives of seniors and immigrants. If you are over 60 or were born outside the United States, you are about to face reporting requirements, enforcement mechanisms, and penalty structures that do not apply to younger native-born Americans. The question is whether you will understand what is coming in time to protect yourself. The mechanics of the change are deceptively simple but catastrophically consequential. Under current law, any United States tax resident must file a foreign bank account report, the FBAR, if their combined foreign account balances exceed $10,000 at any point during the year. That threshold applies universally. Starting January 1, 2026, a two-tier system takes effect. For Americans under 60 who were born in the United States, the threshold remains $10,000. For everyone over 60 and anyone who was not born a United States citizen, regardless of how long they have lived here or whether they are naturalized, the threshold drops to $5,000. For green card holders with pending naturalization applications, it falls to $3,000. Simultaneously, the definition of reportable accounts expands to include foreign pensions not yet paying benefits, life insurance policies with cash value, prepaid cards linked to foreign banks, digital wallets, and even minority ownership stakes in foreign property or businesses that generate no current income. For the first time, the IRS, FinCEN, and United States Citizenship and Immigration Services will share data in real time through an automated cross-referencing system. Every tax return will be checked against foreign bank records. Every FBAR will be matched against reported income. Every discrepancy will trigger automatic investigation. Why this targeting? The official justification comes from Treasury enforcement data. A 2021 study found Americans over 65 were 7 times more likely than younger filers to have unreported foreign accounts. A 2022 Government Accountability Office report showed naturalized citizens and green card holders were 12 times more likely than native-born Americans to maintain foreign financial ties. The pattern is logical, not criminal. People who lived significant portions of their lives internationally, who worked abroad, or who maintained family connections across borders naturally have cross-border finances. 78% of seniors surveyed by AARP in 2023 did not know United States tax law requires worldwide asset disclosure. 81% of green card holders interviewed by the Migration Policy Institute were unaware foreign pensions must be reported. Rather than fix this knowledge gap through education, the government built an enforcement system that makes ignorance legally irrelevant and mistakes financially devastating. The legal framework reveals weaponized technicalities. FBAR penalties for non-willful violations, honest mistakes without intent to hide assets, reach $10,000 per unreported account per year. Willful violations, which the IRS defines broadly to include reckless disregard, trigger penalties equal to 50% of the account balance annually. A retiree with 3 small accounts totaling $15,000 who failed to file FBARs for 5 years faces potential penalties of $150,000 even under the non-willful standard. The statute of limitations on tax returns remains open indefinitely if foreign income goes unreported, meaning audits can reach back decades. The burden of proving non-willfulness falls entirely on the taxpayer, requiring documentation most people never maintained. These penalties are not proportional deterrents. They are designed to terrify people into compliance regardless of the actual harm caused by technical violations. The political dimension exposes mission creep. The Foreign Account Tax Compliance Act passed in 2010 targeting wealthy Americans hiding money in Swiss banks. FATCA requires foreign banks to report accounts held by United States persons or face withholding penalties. Over 100 countries signed agreements implementing FATCA, but enforcement has shifted dramatically from its stated purpose. A 2020 National Taxpayer Advocate report found 73% of FBAR penalties between 2015 and 2019 hit individuals with total foreign assets under $50,000. The median penalty was $47,000 against accounts averaging $12,000. These are not oligarchs. These are working people who made paperwork errors. The 2026 changes will expand this enforcement net by lowering thresholds and automating detection, capturing tens of thousands of additional seniors and immigrants annually. The economic cruelty is mathematical. Consider a naturalized citizen receiving $1,400 monthly from Social Security and $300 from a Philippine government pension earned over 30 years of teaching. She maintains $9,000 in Manila to support her elderly mother's care. Under new rules, she must file annual FBARs reporting the account, report the foreign pension on her 1040 even though it is taxed in the Philippines, and answer mandatory foreign account questions accurately. A single mistake, whether from misunderstanding forms or a preparer's oversight, triggers penalties exceeding her annual income. She cannot close the account without abandoning her mother's care. She cannot renounce the pension she needs to survive. She is trapped in a system treating modest cross-border financial life as presumptively criminal. The immigration dimension creates enforcement leverage potentially more powerful than financial penalties. USCIS has always assessed tax compliance as part of good moral character requirements for naturalization. Until now, officers had limited ability to verify applicant accuracy. The new data sharing platform changes everything. When green card holders apply for citizenship, interviewers access IRS transcripts showing whether foreign account questions were answered, whether FBARs were filed, and whether discrepancies exist between forms. Even if applicants later correct mistakes and pay reduced penalties through streamlined procedures, the fact that corrections were necessary flags the immigration file. USCIS adjudicators have broad discretion over good moral character determinations. Patterns of tax errors, even if resolved, can justify denying citizenship or delaying applications for years. For green card holders, stakes are higher still. Fraud or willful misrepresentation on tax returns can trigger removal proceedings. An immigrant who incorrectly answers foreign account questions faces not just IRS penalties but potential loss of legal status entirely. Public debate splits along predictable lines. Supporters argue the United States has every right to know about worldwide income and assets of tax residents, and people choosing to live in America must accept full financial disclosure obligations. They cite legitimate concerns about money laundering and tax evasion, arguing robust reporting combats these threats. Critics counter the system disproportionately burdens vulnerable populations while missing actual criminals. Wealthy tax evaders use sophisticated foreign trusts and shell corporations not captured by simple account reporting. Meanwhile, a factory worker keeping $5,000 in a hometown bank to help aging relatives becomes an enforcement target. Immigrant advocacy groups argue the rules create unconstitutional two-tiered treatment where foreign-born Americans face greater scrutiny and harsher penalties than native-born citizens. The National Immigration Law Center filed 2024 comments with Treasury claiming lower thresholds for immigrants violate equal protection, but objections were dismissed in the final rule. Media coverage has been minimal, creating dangerous information asymmetry. Major outlets have not extensively covered the 2026 changes because the rules are complex and do not fit conventional news narratives. Spanish-language media and community organizations have raised alarms, but outreach remains limited. By the time most people learn about requirements, it will be through enforcement letters or immigration interview problems. Tax professionals and immigration attorneys specializing in these issues are preparing clients. But the vast majority of seniors and immigrants who self-file or use low-cost preparation services will encounter new mandatory questions on 2026 returns with no advance warning and no understanding of what is required. Looking forward, the most likely scenario involves massive confusion during the 2027 filing season as software flags new foreign account questions, prompting millions to realize for the first time they have reporting obligations. Many will scramble to file delinquent FBARs using streamlined procedures, overwhelming IRS processing capacity. Tens of thousands will make mistakes or provide incomplete information, triggering automated notices and audits. Immigration applications will slow as officers spend more time reviewing tax compliance. Advocacy groups will file lawsuits challenging differential treatment, though cases will take years. Congress may hold hearings as complaints mount, but legislative change is unlikely given bipartisan consensus on strengthening tax enforcement. In an optimistic scenario, Public pressure forces Treasury to delay implementation or phase in changes gradually, with targeted multilingual education campaigns and penalty waivers during transition. This requires political will that currently does not exist. In a darker scenario, enforcement becomes more aggressive as artificial intelligence flags taxpayers based on demographic profiles and country of origin. Data sharing expands to include state agencies and foreign governments, and criminal prosecutions for willful violations become more common. Every element already exists in current law. The question is only how aggressively tools will be deployed. What remains unclear is how the IRS will handle administrative burden. The agency is chronically understaffed. Customer service wait times exceed an hour. Amended return processing takes a year or more. Adding massive new compliance requirements without corresponding resources virtually guarantees system failure. Automated enforcement will proceed smoothly, generating penalties and freezing accounts, while taxpayers seeking to resolve problems face Kafkaesque delays and inaccessible appeals. This is not speculation. It is exactly what happened during 2014 FATCA rollout. The deeper question is whether United States citizenship-based taxation has become incompatible with global mobility realities. America is virtually alone in taxing based on citizenship rather than residence. A French citizen moving to Japan stops filing French returns. An American moving to Japan must file United States returns for life. This model made sense when international migration was rare. It makes far less sense when millions maintain cross-border lives and families span continents. The 2026 changes double down on a system assuming any foreign financial connection is inherently suspicious. For individuals, the path forward is clear. First, create comprehensive written inventory of every foreign account, asset, and income source regardless of size or activity. Include jointly held accounts and those rarely used. Second, determine whether you should have filed FBARs in prior years. If you discover past noncompliance, consult immediately with a tax professional experienced in streamlined procedures. Voluntary correction is infinitely preferable to enforcement action. Third, gather documentation now for 2026. Collect year-end statements, determine highest balances, convert foreign currency using appropriate exchange rates. Fourth, if you are a green card holder planning naturalization, treat tax compliance as critical to your citizenship strategy. Ensure every return is accurate and complete. Keep copies of all filings. Be prepared to explain foreign accounts during interviews. Fifth, recognize you cannot navigate this alone if your situation is moderately complex. Professional help costs far less than getting it wrong. Many clinics offer sliding scale assistance. Sixth, stay informed as rules evolve and guidance is issued. Finally, understand that knowledge and preparation are your only defenses. The system is unforgiving, but if you act now while time remains, you can protect yourself completely. This is about survival in a regulatory environment showing no mercy regardless of intentions. The changes are coming whether you are ready or not. The only question is whether you will prepare before consequences become irreversible.